Hello, it's Phillip Taylor speaking from Richmond, Green Chambers in London. I'm delighted to review this book from Law Brief Publishing about advocacy in the family law world. It's called A Practical Guide to Advocacy in Family Proceedings by Stuart Barlow. Stuart's come up with the goods here. It's a very good book. It's a short book, very readable as always, and it gives you a lot of tips which I think you will find helpful if you've just joined the family bar or you've just become involved in that area of work, because the jurisdiction is different from the criminal or the civil processes. And I think that's one of the reasons why, because I practice in this area, as well as doing both a bit of criminal but mainly civil and family, I do see the differences as we get more and more complicated with all these massive new books, the red book, the white book and so forth. The title I've given for this work is Everyday Advice for Those New to Family Proceedings. Oh, a bit basic, that title, but there we go. But the book is good. There it is. It's a slim paperback. It's the spine. There's not a lot on the back you can probably see. And then inside you've got 134 pages. There's no index, unfortunately, but there's some quite useful stuff dealing with everything that you might want. If I go to the front, there's the front of the book there. Stuart is a solicitor. There's a dedication. Can I just say I only review books that I think are important and good books. Don't review rubbish. This is a good book and it's very useful. Some people have been critical of the simplicity of these books, but they are very helpful for people starting out. Do read the preface at the beginning, which sets out why advocacy is different in the family courts. Law and Procedure is as stated on the 1st of May 2021, and I'm recording this in the autumn. There are 27 chapters in all total, and it covers just about everything you'll do in the family courts, from the fact find to all of the interlocutory stuff to all of the various types of applications, then things like the bundle, evidence on oath, drafting court orders, which we all know having to do for the judges and so forth. There's an introduction, and then you get into the book itself. Chapter 1, why should we undertake our own advocacy? And then you go all the way through. I think it's useful. There's the court hearing itself, very useful again. This is a book which I think would be helpful for people, of which there are a large number now, who are litigants in person, who do the work because it's so expensive. They do the work themselves. They will have help. I do believe the judges and the court staff will help where possible. There are one or two curmudgeonly individuals who will be difficult, but generally speaking, most people understand we're dealing primarily with children. I know we're dealing also with the relationship breakup, but the children part of it is the most important bit. So what do I say? Elizabeth and I talked about the book and I wrote this. So Solicitor Stuart Barlow, who's the author, is a family law specialist wishing to give newly qualified solicitors and legal executives a helping hand in facing their first years in the courtroom when dealing with the tricky aspects of advocacy, and they can be. It's a bit daunting until you start getting into it, and then you build up the confidence and go from there. But every case is different. Sometimes when you go into court, you've no idea what on earth is going on, and it can be difficult. It's happened to me, and it will happen to everybody, so beware. That's why this is a friend to this book. What Barlow does is he hopes that the guide will offer practitioners, quote, details of the important parts of the law and procedure to equip them for advocacy from day one. And that's what you get. We can tell him he succeeds admirably with his mission. Because advocacy in the family courts has a style of its own, he says. Sadly, however, there is not much training or instruction for junior lawyers who have the heart to practice in this area. There are a few books available, but I'm afraid you have to learn on the basis of what has happened in previous cases, and every case can be different. Every CAFCAS report can be different. Every approach by local authority on care proceedings can be different. So you therefore have to be careful. His guide gives us a form of assistance which I think is helpful for newcomers to the family law courtroom. And that's whether you're counsel, a solicitor, or in fact a litigant in person, of which a very large number are. So as I say, this book is helpful for unrepresented parties who are doing it themselves. With the scarcity of legal aid, Barlow brings together in one place, in a short book, written in good English, useful information needed to conduct advocacy in the main areas of family law, including, of course, divorce, financial applications, public and private children matters, injunctions, that's including non-mols and so forth, and cohabitation claims. And it gives us sensible assistance and practical advice for the newcomer on what happens in the family law courtroom. And we found it, of course, very useful as a resource for more experienced practitioners like myself as well, because there's always something that I will miss. And by the way, it's the same with the judges. So don't assume that judges know what's going on either, because sometimes they don't. And they do tend to lead quite heavily on us now, certainly as counsel, to draft orders, which I don't mind that myself, because it gives me a power to make sure that I believe what has been said has actually been put into the court orders. That's not altogether what happens if you're in front of a judge and he does the order or she does the order, and then you don't quite remember from your notes whether that's exactly what happened. But if you've actually agreed with your opponent, then sent it to the judge, it's his order or her order, but at the same time we've got more of an input. Of course, it costs the client more money, but it means at the end that you can make sure that you've tied up all the loose ends. What you get in the book, let me give you an indication. I've listed it. This is what you're getting, depending on what you're looking for. That's getting started as a family advocate, the types of court applications and hearings, the pre-proceedings, that's effectively interlocutories and talking to each other if they're prepared to speak. They generally are in family proceedings, not always, but generally. Preparing court hearings, the court hearing itself, fact-finding, experts, CAFCAS, local authority reports, the court bundles, again. So many people are litigants in person that it is, of course, down normally to that party that's represented by a solicitor to do the court bundle. If they're unrepresented, it will be the party making the application. Then you've got the litigants in person and Mackenzie friends. I think that's useful because the concept of the Mackenzie friend is not understood. They're not there to speak for people, they're just basically there to give a helping hand to the trauma which the party is going through. They're not there for any other reason, really. They're not there to give legal advice, and they sometimes mistake that, unfortunately. Then you've got things like position statements and skeletons. Again, very important, because that's part of the cost with the drafting of court orders, which is right at the end of the book. Those are the things that cost quite a lot of money to do, because quite often you have to produce some sort of skeleton or position statement to update the court on what's happened, because quite often the setting down of a date for a hearing is months before you actually turn up and do the case. Then you've got the issue of appeals and enforcement, of course, of court orders, which, being at the end, of course, is the last and sometimes the most difficult. Let me conclude by saying this, that as a solicitor who's practiced family law for over 40 years, Stuart conducts most of his own advocacy. We've got the experience, of course. He's a member of the Law Society's Children Panel, former Chief Assessor of the Law Society's Family Law Accreditation Scheme, and an adjudicator for the Legal Aid Agency. He also presents valuable training courses for family lawyers throughout the country, and is the author of 3 other law books. And I think they will be of help to people, because you do need assistance. It's amazing, even now I'll have a case, a brief will come in and I'll think, right, I'll just check and make sure I've got it all right, because you never quite know. So thank you, Law Brief Publishing, for producing this work. It makes our lives a lot easier when you produce these books. Obviously, it's a highly charged, emotional area of legal practice in family proceedings for both practitioners and the lay clients. So I'm very grateful to have this book. The date of publication is the 28th of May 2021. As I said earlier, the law is as stated on the 1st of May. Just a quick look at it again. There it is. Little sort of paperback. Not a big book. Nothing much you can see on the back there. Just opening it in a minute. Divorce proceedings. Not a lot really in that area. Contested divorces are not particularly substantial areas now. It's obviously a complicated procedure. Financial applications following divorce and so forth, always important. Then you get children matters, of course, harassment, big area of law. Then the fact-finding is also very helpful. That particularly with fact-finding looks at Practice Direction 12J on child arrangement, where orders where there is domestic allegations of domestic harm. I'm very grateful for this book to be made available to people. When I first started, there was very little on the market, so thank you to Law Brief Publishing and all the other people involved in this book. You do make our lives easier. Thank you anyway. Bye-bye.